The courtroom of Justice Emeka Nwite at the Federal High Court in Abuja was filled to capacity as former Minister of Justice and Attorney General of the Federation Abubakar Malami, his son Abdulaziz Malami, and his wife Asapi Bashir returned to court for the hearing of their former bail applications. Supporters and associates of the first defendants, Malami, were also present in court. At the commencement of proceedings, counsel to the defendant and senior advocate of Nigeria, Paul Daudu, urged the court to grant his clients bail on self-recognizance and other liberal terms. Daudu argued that the offences are not capital in nature, bailable, and that the defendants are presumed innocent until proven guilty by a court of competent jurisdiction.
The prosecution on their own part, rather than proceed with the matter, knowing fully well that they do not have any right of reply, insisted that they needed time and they needed an adjournment for them to respond to what we had found. But taking into consideration the nature of the application, which is an application which is strictly a discretionary one, and based on what we had already earlier filed before the court, we do our further affidavits and proceeded to take the application.
Counsel to the Economic and Financial Crimes Commission, Ekele Iheanacho, opposed the bail applications, arguing that the defendant posed a flight risk. He further told the court that granting bail could lead to interference with witnesses or tampering with evidence.
After hearing argument from the defense and the prosecution counsel, Justice Emeka Nwite has adjourned to the 7th of January to rule on the bail application filed by the defendants. As a result, the former Minister of Justice and Attorney General of the Federation, Abubakar Malami, his wife and his son will remain in the custody of the Kuje Correctional Facility, pending when the ruling is delivered. In Abuja, for News Central, I am Joshua Imarayi.